Hi guys, Mr. Nakamura here, and we're getting ready to start our second day of online learning. Today we're going to be thinking about how cases get to the Supreme Court and what is a worthy case for getting the Supreme Court. We'll be looking at list of justices, what you'll need to get to the Supreme Court, and how they decide which cases they want to hear. Don't forget to be looking in your textbook to answer the study guide and vocab questions on the worksheets that we gave you. Before we begin today, I want us to think about the type of jurisdiction that makes up most of the cases of the Supreme Court and why that is. So thinking about this, we have two different types of jurisdiction that we see in the Supreme Court: original and appellate jurisdiction. We know based on Article 3 of the Constitution that the Supreme Court only has a couple of instances in which they have original jurisdiction. And it's unique because they're the only court that has both original and appellate jurisdiction. But for the most part, for about 97% of the cases that are heard by the Supreme Court, they come through appeals. And we're thinking about how appellate jurisdiction is the ability for them to hear cases from the lower court based on the appeals that they get. What's interesting about the Supreme Court is they also have a lot of freedom to choose which cases they want to hear or which ones they don't want to hear. So let's start thinking about how you can get there. There's a couple of questions that are going to drive the focus of our lesson today. One, how does a case arrive at the Supreme Court, and what exactly is required to get there? Looking at this visual here, you can see that your case might start at the local level in your county or in your state. And if you don't like the decision there, you could work your way up to an appeals court. And if you don't like that decision either, you can appeal to the state Supreme Court, their highest court. But again, if you don't like it and you want to appeal once again, you can try to issue a writ to get to the Supreme Court, though the odds are not really in your favor. And the same goes if you begin in a federal court. You'll start at the district level where you have the judge and the jury that you've seen on TV. And you don't like the result there, you can appeal to get to a circuit court of appeals. And once again, it's very rare because the Supreme Court gets thousands of petitions every year for someone to hear their case, but generally they can only hear and decide on about 80 cases. So I'm thinking about 1% of cases that are accepted. In order to get there, there's three things that you need: standing, lots of cash, and what's called a writ of certiorari. That's a fancy Latin word that we see often in law. And for our purposes, we're just going to call it a writ of cert, C-E-R-T. And that's when the Supreme Court justices agree to hear your case. So let's go through these one by one. First, you need standing. There has to be an actual controversy or some sort of personal harm that's been demonstrated. You can't just say you don't like a law and sue. Next, you need money, and you need money for two reasons. One, the filing fee for the writ of cert is $300 alone, which is a significant amount of money. You also need to make sure you're covering the expenses of all the other levels of court that you've been in, starting at the district level, and then all the other appeals cases that you've been through. And you'll realize through our lessons here that court's very expensive, so you need to make sure you have a lot of money. But there are a couple of things that can lower the cost of the court fees. The first is what's called an informa pauperis. Basically, this is when a party in a lawsuit gets filing fees waived by issuing a statement declaring that they don't have the ability to pay. A good example of this is the court case Gideon versus Wainwright, which we'll actually talk about here later on in our Civil Rights and Liberties unit. Additionally, you can try to employ the use of an interest group to quote-unquote sponsor your case. A really good example of this is the NAACP sponsored Brown versus Board of Education. They covered all the costs in those trials. Also, the ACLU, the American Civil Liberties Union, covers lots of people's cases with regards to the First Amendment. Thinking about what cases to hear, the Chief Justice, who we know is in charge of the Supreme Court, has that fancy title. He'll get a series of memos prepared for by clerks, and clerks are just officers who help oversee filing and maintain records in the Supreme Court. And all the cert requests that come from this person who's called the Solicitor General, this is the head lawyer of the federal government, these cases are automatically discussed. Then we also have capital punishment cases are also discussed here. And it's not, we call this not a frivolous case. A frivolous case are lawsuits that have little chance of being won, but when it comes to capital punishment, we're thinking about very serious crimes, death penalty and such here, so we need to make sure we're discussing these types of cases as well. The third and last thing that you need in order to get your case heard by the Supreme Court is a writ of cert. So this is the agreement to consider a case from a lower court and to make sure we review it. What also goes into the writ of cert, it's an order from the highest court, the Supreme Court, that goes to the lower level court to bring up all the files and all the documents from the case so that they can review it. Part of the writ of cert is also the rule of 4, which simply means 4 of the 9 justices have to agree that they want to hear your case. Looking at some of the numbers from 2008 and 2009, looking at the total number of petitions, there were over 7,738 cases that issued petitions, but only 78 were argued and 75 were decided after the argument. So about 1% of all the petitions that went to the Supreme Court were actually able to get there. So unfortunately, the odds are not in your favor if you want to get to the Supreme Court. There's only 9 of them, and they can only hear so many cases within a year. All right, so next thing you guys are going to do is, now that we've gone over a little bit about what it takes to get to the Supreme Court, is I'd like you guys to take a look at the handout that your teacher has provided on Google Classroom. Complete the capture sheet as you go, and then after you finish both of those items, use what you learned to apply your knowledge to the Google form. And on this form, you're going to be reading over some cases that are given to you, and you're going to want to decide if cert should be granted in this case for the Supreme Court to hear it or not, and then always explain with reasoning. Thank you all for listening today, and don't forget there will be a live chat session at 2 o'clock this afternoon. Hope to see you there.